Hello and welcome to Courts This Week on Live Law. I am Tanya Pandey, here to keep you updated about the latest legal developments happening across India. Do subscribe to Live Law and click the bell icon to not miss any videos from us. Let's begin today's episode with the Supreme Court judgments. The Supreme Court has directed that all states must implement the One Nation, One Ration Card scheme, which enables migrant workers to avail ration benefits from any part of the country by July 31st. The court also passed a slew of other directions for the benefit and welfare of migrant workers, like bringing in place an appropriate scheme for distribution of dry ration to migrant laborers, running community kitchens at prominent places, etc. The suo motu case, which was taken by the Supreme Court in May 2020 to deal with the problems of migrant workers during the national lockdown, was disposed of with these directions. The top court also observed that the fundamental right to life enshrined in Article 21 of the Constitution may be interpreted to include right to live with human dignity, which may include the right to food and other basic necessities. The bench of Justices Ashok Bhushan and M.R. Shah observed that it is the bounden duty of all states and governments to provide food security to impoverished persons. The National Disaster Management Authority has a statutory obligation to frame guidelines for recommending minimum ex gratia assistance for the victims of COVID pandemic, the Supreme Court has held. The court held that Section 12 of the Disaster Management Act cast a statutory obligation on the part of the National Disaster Management Authority to recommend minimum relief for the victims of a national disaster. Such minimum relief will also include ex gratia assistance as per Section 12 Clause 3, the court held. The Supreme Court on 2nd July issued notice in a plea filed seeking directions to the Medical Counselling Committee (MCC) to release the counselling date for NEET MDS 2021 at the earliest and not later than 3 weeks in any event. The petitioners are NEET MDS aspirants and hold a BDS degree. They have challenged the unjust and infinite delay caused by the Medical Counselling Committee in announcement of the counselling schedules for NEET MDS 2021. A 3-judge bench of the Supreme Court comprising of Justices Ashok Bhushan, Vineet Saran and M.R. Shah, took strong objections to a Sessions Court judgment where the name of the rape victim is mentioned. The bench held that all the subordinate courts should be careful not to reveal the identity of a rape victim in any proceedings. The plea was preferred by a rape convict sentenced by the trial court to 10 years of rigorous imprisonment for the rape of a minor girl under Section 376 Clause 1 and 342 of the Indian Penal Code, affirmed by the Chhattisgarh High Court. Bar under Rule 3A of Order 23 shall be attracted if compromise on the basis of which decree was passed was void or voidable, the Supreme Court has held. In this case, the plaintiffs filed a suit challenging a compromise decree contending that it was obtained by fraud and misrepresentation. It was contended that the consent which he gave for compromise by signing the compromise was not free consent and thus it became voidable at the instance of the plaintiff. The trial court and the High Court held that the suit is barred under Order 23, Rule 3A of the Code of Civil Procedure. Rule 3A provides that no suit shall lie to set aside a decree on the ground that the compromise on which decree is based was not lawful. The question before the Apex Court was whether bar under Rule 3A would be attracted in the facts of the present case. The Supreme Court bench of Justices Ashok Bhushan and R. Subhash Reddy observed that the only remedy available to a party to a consent decree to avoid such consent decree is to approach the court which recorded the compromise, and a separate suit is not maintainable. The court also observed that Hindu joint family, even if partitioned, can revert back and reunite to continue the status of joint family, and that the acts of the parties may lead to the inference that parties reunited after previous partition. The Supreme Court has held that persons with physical disabilities have right to reservation in promotions also. A bench of Justices Sanjay Kishan Kaul and R. Subhash Reddy held this while dismissing an appeal filed by the state of Kerala against a judgment of the Kerala High Court. The bench followed a judgment delivered by the three-judge bench in January 2020 in the case of Siddharaju versus State of Karnataka, which held that the rule of no reservation in promotions as laid down in Indira Sahani case had no application to persons with disability. The court also observed that mode of entry in service is not a relevant criterion for promotion under persons with special abilities quota and said that source of recruitment ought not to make any difference. But what is material is that the employee is a person with disability at the time of consideration for promotion, and that the 1995 Act does not make a distinction between a person who may have entered service on account of disability or a person who may have acquired disability after having entered the service. The Supreme Court has dismissed a PIL for declaration of commission of breach of oath by Union Minister General Retired V.K. Singh after he allegedly made certain unwelcoming remarks on the India-China LAC issue. The petition alleged that said speech was intended to bring out hatred, contempt or disaffection, and was an attempt to excite disaffection towards the government established by law in India, and therefore was an assault on the unity and integrity of India, and thus he committed a breach of his oath. Let us now go over judgments from other courts in the country. The Madras High Court has directed the State Judicial Academy to impart training to the stakeholders dealing with the cases under the Protection of Children from Sexual Offences Act, that is the POCSO Act, including the investigating officer, public prosecutor and special judge. A single judge bench of Justice P. Velmurugan was dealing with a criminal appeal against the order of conviction under Section 4 of the POCSO Act. The special judge had sentenced the accused to undergo rigorous imprisonment for a period of 10 years with Rs 15,000 fine, and also directed the Taluk Legal Services Authority to pay compensation to the victim child of not less than Rs 4 lakh. Dismissing the criminal appeal, the High Court enhanced the compensation amount to Rs 5 lakh to be paid by Taluk Legal Services Authority, and also directed the accused to pay Rs 5 lakh to the victim. The Allahabad High Court has denied bail to a man prima facie accused of raping and posting obscene photographs of a woman on Facebook with whom he once had a relationship. The bench of Justice J.J. Munir was hearing the bail plea of one Manav Sharma under Sections 376(1), 506 IPC and Section 67A of the Information Technology Amendment Act 2008. The court remarked that there was some kind of a CD where the applicant was shown threatening the prosecutrix with dire consequences, and that by his words, he had dared the law of not being in a position to save the prosecutrix unless she accepts his proposal. The court observed that this kind of conduct and the offence involved almost amounts to an anti-social activity and a menace to the society. The Jharkhand High Court was hearing a criminal revision against a 2008 order of the trial court, convicting the petitioner under Section 497 IPC and sentencing him to undergo rigorous imprisonment for 2 years. The court set aside the order, observing that there was no indication of prospective application in the Joseph Shine judgment delivered by the Supreme Court, declaring adultery as unconstitutional. The court observed that during the pendency of the revision petition, Section 497 IPC was declared to be unconstitutional, which is a binding precedent under Article 141 of the Constitution of India, and the impugned judgment dated 1st October 2013 was set aside by the High Court, along with the conviction and sentencing order dated 17 July 2008. The Madhya Pradesh High Court has observed that when an accused is asked to give a voice sample by the magistrate, it cannot be said that he is being compelled to be a witness against himself, and thus the fundamental right under Article 20, Clause 3 of the Constitution is not violated in such a case. The bench of Justice Prakash Srivastava and Justice Virendra Singh has reiterated the Supreme Court's 2019 ruling in Ritesh Sinha, which held that a judicial magistrate can direct an accused to provide his voice samples for investigation even without his consent. The court also added that unless the accused is in a position to show that any prejudice is caused with the direction, he has no right of hearing at the stage of issuing the direction. The Telangana High Court has ruled that filing of an anticipatory bail application by a juvenile under Section 438 of CRPC in a writ petition is not maintainable, and that the juvenile has to avail the remedy under Section 12 of the Juvenile Justice, Care and Protection of Children Act 2015. In this case, the juvenile was booked under Section 354 of IPC and Section 7 read with Section 8 of the POCSO Act. In arriving at this conclusion, the court noted that a lot of safeguards were provided to the child in conflict with law in the event the child is apprehended by the police, and thus the child cannot be arrested and need not apply for anticipatory bail. A Delhi court on 2nd July sent freelance journalist Rajiv Sharma to 7 days Enforcement Directorate's custody till July 9th after he was arrested for allegedly supplying confidential information to Chinese officials. ED had initiated investigation on the basis of an FIR filed against Rajiv Sharma under the provisions of IPC and Official Secrets Act. Additional Sessions Judge Dharmendra Rana passed the order on the application moved on behalf of the investigating officer, ED, for custody remand of the accused Rajiv Sharma for a period of 10 days. That's all for this week. Thank you for joining us. I am Tanya Pandey and I wish you a wonderful week ahead.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.